Good morning, Your Honor. Your Honors, may it please the Court, my name is Allison Bancroft. I am counsel for Jason Barbosa. And the question that's presented before the Court today was the effect of the admission of the ballistic certificates that were introduced during the defendant's trial without the testimony of the ballistician who signed the certificate.
Ms. Bancroft, does this come down to a factual dispute? That is, the appeals court opinion states explicitly that the officer was not reading from the certificate, whereas you cite references, and I have to confess to you I haven't gone back and looked, but you cite references which indicate, to you anyway, that he clearly was. And so is that sort of where we're at?
That certainly is one of the issues. The issue is broadly whether or not the testimony of these officers was so powerful that it overwhelmed the effect of the certificate. And one of the factors that the appeals court looked at was they said that he did not read from the certificate to the jury. I argue in my brief that he did actually read from the certificate during his argument, and that's one of the factors that is at issue here. And it's one of the reasons why, even though the Commonwealth didn't rely in closing argument on the certificate, the defendant argues that it did actually have a high evidentiary value in this case. This Trooper Lima was the officer who was testifying. He was holding the certificate of analysis, and
And you know that because?
He actually states on the record, I'm looking at the certificate of examination and test firing from the firearms identification section of the Massachusetts State Police. The defendant then objects, and the judge actually says on the record he's reading from the certificate and he is allowed to continue to do so. The prosecutor then asked questions to this officer and is actually pointed to a specific line in that certificate. So the prosecutor asked, was the gun test fired? The officer says, yes, it was. And then the officer said, so is this the firearm, meaning the firearm that was introduced at trial? He says, yes, it is. And then the Commonwealth asks the officer, were there any malfunctions? And he said, no, there were not. An examination of the record, I believe, does show that he was, in fact, reading from the certificate when he made those statements to the jury.
So you would say, in that sense, it's different, not Dapina, but the other case. I mean, it's different because it wasn't just a statement by the officer that wasn't objected to, that might have been personal knowledge, might not have, but it wasn't objected to. You're saying it's very clear to everybody that this is coming straight from the certificate.
Yes. As I say, he does state that he's looking at that certificate, and that also, in the jury's mind, when he actually read the title of the certificate, and this is a very formal document, and it gives the opinion of the ballistician, that brings the weight of the certificate up in evidentiary value to this jury. And then again...
Did the district attorney make reference to the certificate in final argument?
He did not make reference in final argument. The judge, in his jury instructions, again, reiterated to the jury that they could use that certificate in order to base their decision on whether or not the Commonwealth had proved that definition of a firearm, including the barrel length and the fact that it was operable.
How is this case different than Dapina?
This case is different for a couple different reasons. First of all, it's different in the quality of testimony and the level of experience between this trooper and the trooper that testified in Dapina. In Dapina, the court found that that officer had considerable experience, many years on the force. He was also commander of the firearms division. So, therefore, his testimony could have been looked at by the jury as the testimony of somebody who understood firearms analysis, what happens at the state lab, and it was of such weight that the jury could rely on it. Secondly, his testimony connected the dots for the jury as far as what happened at the scene with the collection of the ammunition. He testified without objection what actually happens at the state lab. He says the gun's fired and the ammunition is sent back to us. And he also testified to the jury what happens when a gun is fired, what a spent casing or shell looks like, and the difference between a spent round and a live round, so that the jury could actually look at the ammunition at the end of, during the jury deliberations and could say, this is spent. I have the testimony of this very experienced firearms ballistics.
Didn't he specifically say that the spent casing was the one that went there and was tested and came back?
He did, in Depina, he did.
Yeah, independent.
Right. So the testimony of Trooper Lima is different. This was a very junior officer. This was his first year on the force. He was still in training. He was with another officer who was his trooper coach. He was specifically not allowed to testify regarding anything that happened at the lab because there were objections based on his personal knowledge. There was no indication beyond the academy that he knew anything additional about ballistics or about the procedures that happen at the state lab. And in terms of what he actually testified to, he didn't testify regarding that entire range of ballistics experience that the trooper or the commander in Depina did. He did testify that there were 6 bullets at the scene, that what came back were 5 bullets in one bag, 1 bullet in another bag marked test. And the most that he did testify was that it appeared that they fired a test round. When looking at this harmless error analysis, the court looks at the certificate along with the other properly admitted evidence of this officer's testimony to determine what effect this officer's testimony would have had on this jury in this case in terms of whether or not it was so overwhelming that it would have nullified the effect of the certificate. The defendant argues that the certificate was the definitive proof in this case that the weapon was operable, that the jury could not have gotten from the officer's testimony overwhelming evidence of the fact that the gun was operable. The fact that he testified that it appeared that they fired a test round, there was no basis for that given in the record. Again, there was no basis that he knew anything regarding the procedures in the crime lab or how he made that determination, and the defendant argues it's akin to an officer in a drug case saying it appears to be cocaine. Well, there's no basis for the jury to decide whether or not that statement comes from some kind of basis of knowledge. It's just not of the weight that the jury would decide to take that evidence over the certificate. When they have the certificate in front of them, the official certificate that actually does, in fact, state that the weapon is a firearm. Well, the other issue that I wanted to address with the court today was the Commonwealth's argument in its brief that the court should look at this case as an expert witness testimony case and evaluate it under a substantial risk of a miscarriage of justice standard rather than under a harmless error standard. The defendant argues that this case is distinguishable from those cases and readily distinguishable. First, because the Commonwealth introduced the certificate as prima facie evidence of an essential element of the crime. And this was not a case where these officers were called to testify as experts. They weren't qualified on the record to testify as experts, and they were not asked to give an expert opinion. And I would submit to the court that this case is more akin to the case in Bullcoming, which is a United States Supreme Court case, in which the court held that even if an expert testifies with the admission of a certificate, if it's not the expert who signed the certificate, then the harmless error standard applies, that it might be a different case if that certificate was not introduced, and it might be a different case if the expert was asked to give his independent evaluation of the work of the analyst, but this is not such a case. Unless the court has any further questions, I would rest on my brief.
Thank you, counsel.
Thank you very much.
Good morning. May it please the court. Alexei Tomasco for the Commonwealth. I would just like to take the opportunity to recognize 2 former interns, Alex Leff and Alicia Wilson, who helped prepare the appeals court brief. This court has never had an opportunity to review Commonwealth versus Pittman, and 17 appellate decisions have relied on that case. Here, the appeals court specifically relied on DePina and Pittman. Your Honor, I believe under either case, but particularly under DePina, the appeals court was bound by this court's decision.
But, I mean, in DePina, there was a spent cartridge found in the gun. Doesn't that fundamentally change the quality of evidence from what we found here?
I don't believe that this court set up a bright line rule that said in the case where there's a spent casing and only in that case there's no harmless error. And I think review of this court's opinions, yes, in DePina there was that requirement or that factual finding, but I'm not sure in any of the other cases where this court has found harmless error.
Doesn't it at least suggest that that the appeals court was bound by DePina to find this way? I mean, that's a huge difference, isn't it?
I'm not sure it is. I think the fundamental issue in DePina is not necessarily just the spent casing, but actually this testimony that we have describing the procedure, someone describing what the ballistics testing is.
Do you agree that the officer was reading from the certificate?
I'm not sure it matters, Your Honor. I mean, I certainly think in that the offer of the certificate, apart from the expert analysis the Commonwealth proposes, if we accept that the certificate is offered under standard, under Melendez-Diaz analysis, it's harmless error regardless of whether he read from it or whether it was offered.
Well, but if he read from it, it isn't really his opinion.
Yeah.
I think
He's not expressing an independent opinion.
in terms of the functioning.
Yeah.
Well, I mean, I think this court has certainly said multiple times that merely because an individual, particularly in expert testimony cases, if the witness agrees agrees entirely with the certificate, that's not necessarily a problem. However, I would suggest independently where we have Officer Guerrero who comes in and says, I did verify that it was an authentic weapon, I think we can separate those issues.
That doesn't mean it's a working firearm, though, does it?
I think it does, Your Honor. I mean, how is that different than the certificate that says, in my opinion, it's a firearm? That's it. That is the entirety of the ballistics certificate.
Well, wasn't the issue about authentic weapon that it wasn't a toy gun or something?
I'm not sure that's the case, Your Honor. And I certainly think that where you have the officer on the stand, the defendant could have come up and said, what do you mean by authentic? And certainly there's good reason. We're not, the issue in Melendez-Diaz is the right to cross-examination, and that was presented when an officer came forward and said it's authentic. It's authentic.
Back to Judge Spina's question, though. You said you don't think it matters, but just so we're clear, he was reading from the certificate, wasn't he?
I think, Your Honor, my impression is that he certainly read the sentence that said this was a firearm.
So he was reading from the certificate.
I think on that line. That said, I think to the extent that we see the rest of the certificate itself copied his notes verbatim, and he authored the notes that came in. I think that's emphasized over and over again, that he testifies, here's what I wrote on this piece of paper. The ballistician copied that. I would also point out that in the Commonwealth's appendix, you certainly have the picture that the description of the weapon, the Speedy 6, is actually etched into the firearm. So it's not a matter of the police officer providing any additional information. It's actually written on the gun. So to the extent that that was offered, the jury could see it.
Do you agree that the testimony in DePina from a firearms specialist describing how the lab process works in the test firing of weapons that was not present in this case was an important piece of evidence in the DePina case?
I disagree as to that factual statement that it wasn't present, and I point to the court's ruling that on Trial 1208, Officer Lima, can generally talk about what happens with guns and test fires. The trial court specifically allowed Officer Lima to testify as to that point, and I think he came in and he did describe it. You see that again during cross-examination on transcript 2, the defense attorney does get in and touches on the ballistician testing. So I think that it's the same thing in each case, and I think that's one of the reasons the court particularly relied on DePina in this case. And again, I think that's one of the issues that I see the import of DePina, this notion of describing what the process is, sending off the 6 bullets, and again, chain of custody is particularly strong in this case, showing that the officers packaged the gun, brought it to the evidence locker, brought it to the testing facility, described that at the testing facility a piece of ammunition is loaded into the gun and it's fired, and that they then pick up the weapon and there's an empty casing and 5 bullets. I think that's precisely what's in DePina. To the extent that we're delving into the credibility or the evaluation that a jury might take on witnesses, I certainly am not familiar with the facts beyond what this court wrote in DePina, but I think it's a difficult decision at that point in time, and I would point out that it's the jury's provenance to examine these, and to the extent that we're looking at it, we may be looking at it as in a Richard Nixon Kennedy debate, where on the transcript one witness might look stronger, but in person the other witness might look stronger.
But that goes to the issue.
I'm sorry, go ahead.
But that goes to the issue of the sufficiency of the evidence, not to whether or not the evidence is harmless beyond a reasonable doubt, or the admission of the evidence is harmless beyond a reasonable doubt.
Well, I think, Your Honor, whenever this court has reviewed for harmless beyond a reasonable doubt, this court has reviewed in terms of the overwhelming evidence. So I think to the extent that we talk about...
And the inference with regard to what was returned from the procedure of the ballistics unit combined with what was returned, you say is overwhelming evidence that makes it harmless that they admitted the certificate which says it's a firearm?
I think DePina has certainly emphasized that, but I would point, in addition to here, Guerrero's testimony, I think to the extent that this court, again, I mentioned the bright line in terms of loading an empty casing into a non-operable weapon, but I'm not sure that's distinct from loading a non-operable weapon with bullets. You could look at here and say there's multiple different kind of bullets in here. This is not an accident about how they were loaded. That loading an empty casing into a firearm is particularly influential. Doesn't mean that loading an operable bullet.
In DePina, the inference was not that it was loaded. The inference was that it was left after a firing, that the cartridge, that the gun had been fired, and the cartridge remained in the gun because it was a revolver and not a semi-automatic.
Yes, Your Honor. My point here is that might be particularly compelling doesn't mean that the other inference is not compelling as well. It may be an A+ inference versus a B+ inference, and I think... But
if you have a B+, is B+ overwhelming evidence sufficient to be harmless beyond a reasonable doubt?
Well, I think this court has said definitively that a loaded firearm by itself does not constitute harmless error, but I think we have much more than that, and I think the DePina aspect of this in terms of the ballistics testing is a big portion of it. And again, I think where I have a real difficult time distinguishing between the certificate opinion, it is my opinion the evidence is a firearm, and Guerrero's testimony that I verified that it was an authentic weapon.
And not a replica.
Yes, Your Honor.
Well, that doesn't necessarily tell you it's going to be a working one.
I think he says in 2 different statements that the first one he wanted to verify it was authentic and not a replica, and his second statement on the same page is that he, quote, lifted it up, touched it, and confirmed that it was in fact authentic. Our issue here is the right to cross-examination. He did that. I think when we look at the bare statement, it's my opinion that's a firearm. I'm not sure that necessarily provides anything more than this. If you had the ballistician there, what was the question you'd ask him? What does that mean? What does it mean that it's your opinion it's a firearm? The question you ask here is, what does that mean? What does it mean that it's authentic? I don't see that there's any distinction there in terms of exactly what the cross-examination right is. If we're saying that the jury cannot independently assess what the firearm is, and I think this court has actually distinguished that and said maybe that's the case, are they of such legal acumen or firearm acumen that they can say firearm and authentic are different things? Firearm is a term of art and authentic isn't. I'm not sure that's the case. That's why we have a witness come in and say it's a firearm or say it's authentic. And that's the remedy here is cross-examination.
This has already been alluded to a little bit, but in Commonwealth versus Muniz, there was where we went the other way and said that there was not overwhelming evidence of guilt when a certificate was admitted. The gun that was involved in that case was a semi-automatic pistol, and I'm not clear from the opinion as to whether or not any of the spent cartridges were returned with the magazine and the live cartridges that had been in that gun. But does it make a difference if it's a revolver versus a semi-automatic, and if bullets don't come back, the same number of bullets don't come back, one spent or some spent and the remainder live?
Just to address in Muniz one point, I would say that this court emphasized that there was no testimony about how guns work or ballistics tests, and again, that was emphasized. I think if you have the bag of ammunition and there's no further, if you have a bag of ammunition and there's no indicia of testing, and in Muniz it's very clear that there was no description of that, I think you may have, I think you have a very distinguishable case from DePina, to the extent that, you know, we don't know whether the ammunition worked or not, but there's no inference that's capable there. In terms of just the physical distinction of a semi-automatic versus revolver, I'm not sure that's a meaningful distinction. The notion for the ballistics testing is you have a gun that's loaded and you send it off and they pull the trigger and fire it, send back what was delivered to them with the modification that a bullet has turned into an empty casing. I'm not sure there's a distinction there between the revolver and the semi-automatic. At the ballistics testing, they pull the trigger and you just track down where this casing is, and the one it ejects out of the weapon and the other it stays in the weapon. But again, the emphasis here is you send a package of bullets, you come back with less bullets and a empty casing. I think those are tangibly different objects. I know defense counsel suggests that, you know, they're all the same. 6 bullets come out and 6 bullets return. That's just not the case. A casing is readily distinguishable from a bullet if you hold them or look at them. But so I think Muniz is actually a very strong case for the Commonwealth, where this court emphasized the lack of testimony that you had in DePina, or we have here, where someone says, here's how guns work, here's how bullets eject out of guns, and here's what happens in the ballistics testing, and then the return, the strong inference of the return of a casing instead of 6 bullets. And I think that's quite critical here. I think that's why the appeals court in both Pittman and in this case followed DePina. And again, I acknowledge that Pittman, the appeals court has relied on it repeatedly. This court has never given further appellate review in that case or any of the Pittman descendants. And this is the first case this court has had an opportunity to look in at Pittman. But I think all of these cases are, I think they're indistinguishable in terms of DePina or Pittman or Barbosa here. If I could address briefly the expert analysis, I noticed that several of the justices had sour looks on their face when defense counsel mentioned that. But I do think, I think the analysis here is very distinct. As I mentioned before, the court specifically said that Officer Lima could testify about how guns work and could testify about test fires. And I think what we see, for instance, in Zeinger, where there's a discussion of the officer's expert opinion and qualifications there, that we're really looking, and I think this is why this court's decision and the appeals court decisions have come down differently, is that what we're really looking at is a variation and not a straight Melendez-Diaz, because what we have instead is someone describing the process just like we would have in medical testing or an autopsy or a DNA test. We have someone who's relying on a document. And yes, it's still error under Barbosa and Grenadier to offer that or discuss it in direct, but I think our analysis is different because what we're looking at are the opinions. We're looking at the opinions of officers.
What is the opinion here, though?
That it's a working firearm.
Reading
That's
from
authentic.
the certificate.
But that's exactly what we have in Barbosa or Grenadier, is we have the certificate
it's
offered.
exactly not that. It's that the person has an independent opinion. It's not just reading from the autopsy report.
This court has said that the fact that the opinions are the same, and I think...
No, but the point is the person testifies independent of reading from the report, that based on the report and the other information and the photographs, et cetera, et cetera, et cetera, it is his or her opinion X, Y, or Z. I don't see that here.
Let me take for a given that those are important distinguishing features. That doesn't change our analysis, that it shifts us from harmless error to a substantial risk. And I think that is the important distinction that I'm making here, is that, again, I concede readily that the offer, whether under expert analysis or under Melendez-Diaz, is error, but where we have that testimony that precedes the certificate, where here's how it works, here's what actually goes into the testing, and here's what comes back, we don't have an objection here, so a substantial risk.
I'm just suggesting to you that if, well, never mind.
And Your Honor, again, I would point out the difference between between Officer Lima's testimony and Officer Guerrero's testimony, that we have Officer Guerrero who repeatedly testifies as to his training and expertise and comes in. I think we look at the distinction between Lima's testimony and Guerrero's testimony, where Guerrero was aware where all the serial numbers are on guns. He did have that added level of expertise, and he comes in and he makes a statement, a statement as to his opinion as to what the gun is, what the firearm is. Seeing as there are no further questions, Commonwealth will rest on its brief.
Thank you.
Thank you, Your Honor.